As you likely remember, this bill relates to the minor work exemption in the contractor's law. Existing law says that a contractor's license is required for any project valued at $500 or more in labor and materials. This bill raises the threshold to $1,000, providing the scope of the project does not require any building permits or hiring of employees. For the board's awareness, this bill was amended since the board took a position of support on it at its June 13, 2024 meeting. At the time, the bill provided that an unlicensed contractor would no longer qualify for the exemption if they engage in specific identified activity or work, such as certain trades or structural behind-the-wall work. Those limitations were removed from the bill on June 27th. Because substantive changes were made to the bill after the board took a position, staff could not communicate the board's position of support until the board had the opportunity to review the bill again, which could not occur before today. As a result, the board has no position on the bill. CSLB anticipates increased enforcement workload as a result of this bill, as in seeking budget authority to hire 2 permanent special investigators. Staff will also need to update its publications, both printed and on the website, and educate staff regarding the new changes. Lastly, staff plans to monitor consumer complaints regarding projects between $500 and $1,000 to determine if any consumer harm is occurring as a result of increasing the exemption amount. Are there any board member comments or questions on this item?
Mr. Chair, I have a question or comment. I would like to request that Rebecca May look into AB 2622. It's my understanding that this bill takes effect immediately, not in January. So we just need to confirm that. Thank you.
Thank you, Member Love.
I'd be happy to look into that and keep you apprised.
All right, thank you. Any more comments or questions from the board?
One comment right here.
All right, Chairman Mark.
Thank you. Yeah, this was obviously an important bill, and there was a lot of discussion. I appreciate staff continuing to look at that $500 to $1,000 range if there is actually a lot of unlicensed or actual consumer harm by now potential unlicensed contractors via the more handyman status. That would be good data for us in the future as potentially this dollar amount tries to be raised every year as we go forward. In the end, consumer protection is very important, and we need to make sure we have as many licensed contractors as possible. So,
thank you, Chairman Mark. Any other questions or comments from the board?
Chair Mark, did you mention it gets raised every year?
no. There is continual legislation every year where if you remember this bill when it first became addressed, they were trying to raise the rate to $5,000. So at that point, this board opposed that. But there's always, every year, there's always legislation of trying to, so that was my comment. Thanks.
Thank you.
Any other questions or comments from the board? Seeing no further board members' comments or questions, let's take public comment. Are there any members of the public wishing to comment regarding this agenda item? Seeing none, thank you. The next bill up for discussion is AB 2677, Chen. An analysis of this bill can be found on the board packet on page 108. This bill passed the legislature on August 30th and is now pending the governor's signature. This bill would limit a surety company's liability for attorney's fees and cost in a civil case to the amount of the license bond. Should the governor sign this bill, it will be effective January 1, 2025. The board has a support position on this bill. Before asking board members if they would like to provide any comments, I understand Registrar Folk may have a comment on this item. Registrar Folk.
I don't know. Rebecca, would you be able to answer that one?
I thought you wanted to answer it. I thought you had
No, you go ahead. That's fine.
I'm sorry. I thought
With
you
no
wanted to maybe
comments,
talk about
I
the
would
boards.
ask if any of the board members has any questions or comments on this agenda item. Seeing none, thank you. The next bill for discussion is SB 1455 Ashby. This is the board sunset bill. As you may recall, the board took a support, if amended, position on the bill at its June 13, 2024 meeting, and took a full support position on the bill at special meeting of the board on June 21, 2024. An analysis of this bill can be found on the board packet on page 111. This bill passed the legislature on August 30th and is now pending the governor's signature. As you remember, this bill extends the board operations until January 1st, 2029. This bill would also allow CSLB to recoup the costs of its industry expert inspections on workmanship complaints that result in a letter of admonishment or citation. It will, too, provide that licensees pay license examination costs directly to the examination vendor instead of CSLB. 3, include federally recognized tribes among the entities to which CSLB can issue a contractor's license. 4, require the awarding authority in a public works contract to select contractors in accordance with their licensing classifications. 5, delay the requirements for all licensees to carry workers' compensation insurance until 2028 and require CSLB to establish a process for verifying how an applicant or licensee may obtain an exemption from this requirement by January 1st, 2027. I want to thank Board Member Miguel Galarza and myself were appointed earlier this year to a 2-person advisory committee to study this issue. We are scheduled to meet on October 22nd and should have an update for you at our next board meeting in December. Presuming this bill will be signed by the governor into law, CSLB staff plan to be ready to implement SB 1445 by its January 1st, 2025 effective date, particularly as it relates to licensing federally recognized tribes. Are there any board members, comments, or questions on this agenda item?
I have a comment. I appreciate the time that's going to be spent as we're trying to implement that last piece of the sunset bill. So appreciate Board Member Galarza, Board Member Barton on that 2-person committee.
Thanks. It's our pleasure. And any comments or questions? Okay, before I close, Mr. Jametsky has requested we go back to AB 2677. Is there any?
Yeah, Member Bard, if I could comment on that, I actually do want to comment on that bill. It's very important to me, so.
All right.
I don't remember exactly what kind of profound statement I wanted to make, but the card bill is of great concern to the CSLB because we don't want there to be any confusion about whether the Contractor State License Board is a surety company. The Contractor State License Board is not a surety company. We do not sell bonds. We have no authority to be dispersing a cash deposit without a court order. Initially, we were hoping that something could be put in the sunset bill to clarify that. It didn't get in the sunset bill. The industry has a bill that was successful. I just would encourage our legislation chief and also the board to continue to support some type of legislation in the future to really clarify in statute that CSLB is not a surety company and not subject to paying any attorney fees in any matter relating to a bond or a cash deposit. Even though it seems pretty straightforward, the problem can be that an attorney may look at it differently and file a lawsuit against the CSLB, and we have to defend it, and it does cost the board money to do that. So I just want to flag that for future potential legislative consideration, Rebecca. Thank you.
Thank you, Registrar Vogt. Any other comments or questions from the board on the legislative agenda?
I have a comment.
Mark.
Thank you. Going back to the sunset bill, did I hear that it's still waiting to be signed? Is that what I heard?
Yes.
Correct. The governor has until September 30th to sign legislation. I anticipate he'll sign this bill.
Thank you. And I want to thank again past Chair Diana Love and Board Member Galarza, who spoke on behalf of our board at the sunset hearing. They did a wonderful job. Appreciate your hard work. And There was a lot of things within that sunset bill that's very important to our board, and appreciate Senator Ashby for carrying that bill.
Yep, agreed. Thank you, Chairman Mark. Any other comments?
Yeah, I had a question on 2677. So there's, the contractor can either put a cash deposit or a bond down, correct, for $25,000. The way I read 2677 is that bonding company would be liable for up to $25,000 of damages from the claimant and $25,000 in attorney's fees. That's capped. So they're capped at $50,000. If there's a, and I think this is what Dave's referring to, but I just want to know how it stands right now. If there's a $25,000 cash deposit, that $25,000 covers damages and attorney's fees right now?
Do we have the answer to that, Mike? I'm not sure. We know that we have had a situation, though, where we were being asked to pay for attorney fees, and that was the concern. So is that known?
So, yeah, it's unknown. We could have a cashier's check. We stop accepting cash deposits. So it'll be a cashier's check in the amount of the bond for $25,000, the license bond. That goes to consumers harmed by the violations of the contractor's law by the contractor. Separately, there has been prior litigation that has determined that because CSLB will hold that cash, they can be considered a surety under this civil code thing that we're dealing with this AB 2677. So the registrar's point was, in addition to this AB 2677, CSLB needs to get on top of its legislative change to make sure that it's clear in the law that we're not a surety.
Well, just to reconfirm this, though, we have no authority here at the board to pay out on any cash deposit without a
Yeah.
court order. So we don't believe we should have any liability whatsoever to pay any attorney fees. We're not involved in it. We have no authority to make a good faith payment. It requires a judgment and a court order. So I just want to make that really clear. We should not be paying any attorney fees whatsoever because we are required by law to accept a cash deposit.
I left that part out because we have a cashier's check on file. In order for a consumer to claim that, they have to file in court. And when that occurs, that's when the attorney's issue arises.
May I just add that I think you said 25 for liability, 25 for fees. I don't believe that is the case. I believe the law for sureties, awaiting signature, is that the bond limit is a cap on damages and fees, so it would be at $25,000. And as far as we are now, the process we have is if there's any question, we are interpleading or depositing the full amount of the deposit with the court and letting them fight over it, and that eliminates our liability for fees under the civil codes.
Thank you for that. All right, any other questions or comments on the legislative agenda? All right, thank you. That concludes the legislative report today. Back to Chairman Mark.
Thank you, Joel. Great report. Next, we will move to enforcement, beginning on item E. We are now on the enforcement section of our agenda. Before I turn it over to Enforcement Committee Chair Rodney Kobos, I'd like to acknowledge the work of staff in putting together the upcoming partnership meeting of collaboration on public works, commercial enforcement strategies, underground task force that Register folk, with the help of Enforcement Chief Steve Grove, is spearheading this event, and for convening all of our state and federal partners and CSLB public affairs staff for the work on this communications and content as well. With that, I will turn it over to Enforcement Chair Rodney Kobos.
Thank you, Chair Mark. Good morning, everyone. I am Rodney Kobos, Enforcement Committee Chair. The first item on the enforcement agenda is the review, discussion, and possible action on the 2025-2027 Enforcement Strategic Plan Objectives, which begins on page 117 of your board packet. Objective 2.1 is to address false advertising online and on social media to increase proactive enforcement and consumer awareness. To accomplish this objective, it will first be necessary to identify how much illegal advertising is taking place online and in social media. This will require an independent consultant to conduct a statewide study. Fortunately, this is already in progress in alignment with the next objective 2.2. Once we have the data on the amount of illegal advertising, the methods used, and the geographical locations where it is most prevalent, a plan can be developed for addressing this issue, which will determine the resources needed. One option that is being considered is redirecting some SWIFT investigators from routine sweeping operations to monitoring and addressing illegal online advertising. Objective 2.2 is to assess the need for additional resources to address unlicensed activity and to ensure sufficient staffing. To address this objective, CSLB is in the process of hiring an independent consultant to perform a study on the size of the underground economy in California and the resources needed to respond to natural disasters. Objective 2.3 is to review and strengthen penalties as necessary to ensure they are adequate to deter violations. While this is an Enforcement Division strategic objective, implementation will fall on the Legislative Division to first find an author for the bill and then ensure legislation is introduced to increase minimum civil penalties, many of which are as low as $100 and have never been increased. It is important to note here that we are focusing on increasing minimum rather than maximum penalties because it is an all too common occurrence for the administrative law judge to reduce civil penalties to the minimums at a citation appeal hearing. It is critical that civil penalties are significant enough to serve as a deterrent for future violations. Objective 2.4 is to leverage partnerships with external stakeholder groups to increase the support for enforcement efforts and improve compliance. The Enforcement Division intends to accomplish this objective by hosting and/or attending various meetings with construction compliance groups who focus on identifying contractors who violate licensing laws intended to create a level playing field for all contractors. The Foundation for Fair Contracting, or FFC, hosts an annual team summit with their compliance agents, the Division of Labor Standards Enforcement agents, and investigators from the CSLB Quality Assurance Unit. The next team summit is scheduled for October 2nd, 2024 in Sacramento, and CSLB investigators will attend. Thanks to Board Chair Michael Mark, a meeting location has been secured at the State Building and Construction Trades Council of California for a strategic partnership meeting with Employment Development Department, Division of Labor Standards Enforcement, Cal-OSHA, California Department of Insurance, and the Federal Department of Labor. Field compliance agents from multiple construction compliance organizations will be in attendance to learn the best practices for submitting complaints and leads to the state and federal agencies. This meeting is scheduled for October 21st, 2024. This concludes the review, discussion, and possible actions on the 2025-2027 Enforcement Strategic Plan objectives. This is an informational item only. No action is required of the board. Do any board members have any comments? Okay, are there any comments from the public here in the room? Robin, please check to see if there are any comments from members of the public on WebEx. Thank you. E2, Enforcement Program Update. The next agenda item is the Enforcement Program Statistical Update, which begins on page 121 of your packet and includes a thorough statistical update. However, at this time, I'll request Enforcement Chief Steve Grove to provide a couple of highlights. Steve.
Thank you, Member Cobos. I have two highlights of recent investigations I would like to share this morning, beginning on page 124 of your packet. The first highlight is titled Accessory Dwelling Units Abandoned After Collecting a Large Sum of Money. In December of 2020, a property owner entered into a written contract with licensed contractor Jarrett Construction to construct an accessory dwelling unit in San Mateo for $193,000. Jarrett received an excessive deposit of $5,000, 5 times the legal limit, prior to commencing work. The project began in December of 2020 and ceased in July 2021 when Jarrett abandoned the project after receiving over $125,000. The property owner was forced to hire another contractor to complete and correct the project for a cost of $250,000, resulting in a financial injury of more than $180,000. During the investigation, multiple violations of contractors' license law were established, including abandonment, departure from trade standards, failure to complete the project for the contract price, and collecting an excessive down payment. In April 2023, the investigation was completed and an accusation was filed with the Attorney General's office. The respondent eventually agreed to a stipulated settlement to revoke the license, which was adopted by the Registrar in April of 2024. The next highlight I would like to share is at the bottom of page 125 and is titled Licensee Charged with Aiding, Abetting Estranged Husband's Unlicensed Contracting Activities. In July of 2024, a peace officer in our Special Investigations Unit completed a complex investigation involving a licensee who aided and abetted her estranged husband who was running an unlicensed construction business. Her husband's contractor's license had been revoked in 2021. The investigation began after the CSLB received multiple consumer complaints filed against the revokee. From November 2021 through March 2023, the revokee fraudulently represented himself as a licensed contractor, entered into contract with homeowners to perform various contracts such as remodels and accessory dwelling units. The revokee used contractors' license numbers that did not belong to him on several of the projects and requested and received money in excess of the value of work performed. A search warrant was obtained for bank records, which showed that the husband and wife collectively received over $540,000 for 9 projects. Construction at the victims' residences were not completed, forcing them to hire others to complete and correct the projects, resulting in significant financial harm. For 2 of the projects, there was money paid and no work performed or materials delivered. In December of 2023, the case was referred to the Orange County District Attorney's Office, where it is currently pending a filing decision. Charges alleged in the case include diversion of construction funds, theft by false pretenses, grand theft, fraudulent use of another's contractor's license, conspiracy, and contracting without a license. The case was also referred to the Attorney General's office seeking revocation of the wife's contractor's license. This includes my highlights. I'll turn it back over to you, Member Kobos.
Thank you, Steve. Continuing on with the statistical update, you will note at the top of page 123 some staffing information. Enforcement supervisors and managers continue to prioritize filling vacancies. As of July 31st, 2024, there were only 10 vacant positions, which is a remarkable 2% vacancy rate. Interviews have already been conducted and candidates selected for the 5 of these vacant positions. At the bottom of page 127, you will find complaint statistics. For the period of January 1st, 2024 to July 31st, 2024, a total of 11,940 complaints have been initiated, which is significantly more than what the Enforcement Division can process in a timely manner. With current staffing levels, the optimum maximum Enforcement Division caseload is 4,860 pending complaints. As of July 31st, 2024, the pending caseload was 5,734. The major contributor to this increased caseload continues to be residential solar installation complaints against a small number of contractors that are receiving an excessive number of complaints. As discussed in prior board meetings, our newly formed multiple offender unit is tasked with investigating contractors with 10 or more complaints and taking swift and aggressive disciplinary action when violations of contractors' license law are identified. Staff Services Analysis, SSA, and Special Investigators, SI, in the Enforcement Division are working very hard to keep up with the incoming complaints. The weighted monthly case closing average per special investigator in the investigative centers remains steady at 8 closures per month, 2 less than the closure goal of 10. SSAs assigned to 2 CSLB intake mediation centers have done a remarkable job of mediating consumer complaints. From January 1st, 2024 through July 31st, 2024, staff's efforts have resulted in approximately $25 million in restitution to financially injured parties. Another board goal is to appropriately disposition all but 100 complaints within 270 days of receipt. As of July 31st, 2024, 281 complaints exceeded 270 days in age. Enforcement supervisors continue to work closely with their staff and provide guidance during monthly case reviews in an effort to reduce the backlog of aged cases. And I am pleased to provide an update that at the end of August, cases exceeding 270 days in age were reduced to 259. At the bottom of page 128, you will find information regarding CSLB-sponsored arbitration and disciplinary action statistics. Let us know if you have any questions about those. And finally, I will provide a brief update on proactive enforcement, which is conducted by 27 special investigators assigned to the Statewide Investigative Fraud Team, or SWIFT. This information begins on page 130 of your packet. From January 1, 2024 to July 31, 2024, SWIFT conducted 24 undercover sting operations across the state, participated in 212 sweeps, and responded to 569 leads or tips received from industry and the public. Investigators closed 1,869 cases as a result of the operations, with 542 cases resulting in an administrative or criminal legal action. Additionally, over 679 advisory notices were issued for relatively minor violations. And finally, beginning at the bottom of page 131, you will see that the Enforcement Division Experience Verification Unit has conducted 760 application investigations during the period of July 1st, 2022 to July 31st, 2024. Of that total, 444 were verified or approved, 126 were withdrawn, and 182 were denied, and 8 denials were appealed. That concludes the enforcement program statistical update. On page 133, you'll find the enforcement training update, which includes the current week-long enforcement academy, which began on Monday of this week here at the CSLB headquarters. This is an informational item only. No action is required of the board. Is there any comments from members of the board? Jamar.
Yes, thank you, Enforcement Chair Cobos. I have maybe this is kind of a question for staff. I appreciate the comments on the ADU case that was from 2021. That case is very similar to what was happening and was spoke about at yesterday's legislative committee meeting. I think just for the public, and this is just something for us on our website, there was a lot of great suggestions that was stated from public yesterday. But one of the things that we really need to stress is making sure when homeowners have a contract in place that there's actual progress payments being completed instead of money being paid up front for the entirety of the project. So we just need it's just almost like a public service announcement right now. As work is being completed, do not pay your bill in full. And maybe Registrar Folk can actually speak a little bit more on this. It is illegal to request as such greater than initial deposits. And a lot of this items with Anchor Tiny Home might have been prevented if our consumers out there did not pay in full.
Yeah, I'd like to make a comment regarding that. We have put a memo out to all staff explaining that monitoring the progress payment is really a core value with CSLB. You know, what we're seeing with some contractors is that they are highlighting in their contract that they can't take more than $1,000. And then they take a second or third payment that far exceeds the work that's being paid for. We did recognize that, and Catherine, probably 6 months ago, we put on the CSLB website right on the front page a caution that you need to be sure that when you're making those subsequent payments that it doesn't exceed the value of work. But it was tailored to solar, but now we have ADU doing something similar. So I think we still have the solar cautionary notice up, but we need to expand that into any other trade that would seek to do that same kind of activity. Catherine, do you have any thoughts on that?
I would agree with that. I think we should still have the solar one up, but I think we should have one for ADUs, for any other ones where we're really seeing this progress payment issue come up. And I know we've already talked about some language to include on ADUs, and I know we've also discussed potentially doing also an industry bulletin, pretty much just reminding industry, you can't be taking this much up front.
Is there a way to, I don't know, maybe it's a question for Jason, but to do a little bit more like a banner or something, really, a consumer beware type notice on the website so it really stands out?
Yeah, we currently have the what's new and the alerts on the front page of the website, so we can put any information that's necessary.
I'll just make a comment. So consumers out there, if you're asking to be paid in full and only 5% of the work is being completed, do not pay in full. And if you need help, you can contact CSLB for the memo on progress payments, and then you could send that to your contractor.
I guess just a comment from myself. I was just wondering, when there is an update on the website, can members of the public sign on to get updates when they're posted?
Yeah, at the CSLB website on the front page, just any member of the public that accesses it would see that information, and we want it to really stand out. We also have a section, though, that's titled What's New at CSLB, and again, it's on the front page. So we use that to try to help the public understand how they can protect themselves and make sure that's first and foremost when they look at our website.
Thank you. Okay, any more comments from the board?
Yeah, just, we talked about it before. Most folks are not looking at the CSLB until it's too late. Is there any ideas or thoughts about maybe even reaching out to maybe the banking industry that is actually providing these loans to consumers, maybe giving them the fact sheet and encouraging them to share that information with those that are applying for those loans? But I don't know if that would work or if they would do it, but just a thought.
Yeah, it's a great thought, and we've had members with lenders regarding that exact issue. And those meetings were in relationship to solar, but it's really troubling that many lenders, and green funding especially, they want to pay the contractor directly. And what we've strongly encouraged them to do, if that's the case, if you're paying the contractor directly, you need to be very clear on don't pay the contractor unless that work has been performed. You need to verify it in some way. Now, with solar, we were able to work with a solar expert in establishing the value of the permit and the plans for a solar project, and that's generally $3,000. So we're able to put that information out to the public and our staff that for second payment should be $3,000. With the ADUs, it's a little bit different. We did some research, and we found that many building departments have ADU plans at no cost. So why would a contractor be charging for ADU plans when there's no cost? But then others, if you hire an engineer or an architect, it could be much more, it could be $10,000. We don't know. But what we need to do is put information out that as a consumer, if you're being asked to pay for plans or permit, you need to verify that that's been paid. You need to confirm with that engineer that drafted those plans, that engineer was paid, because you're paying for something that you may not have and may not be of any value to you. So that is a priority here, to work with public affairs and put additional information out as it relates to ADU. You know, what we've seen in some situations is that contractors are receiving up to 70% of the contract price when there's no work of value that's been performed. And that's not okay. That's an illegal act. Contractor cannot request and receive progress payments that exceed the value of work for residential construction. Can we do more to educate the public? Yes, we can. We can work with the lenders. We're looking to work with the California building officials, put together a frequently asked question document, and to really emphasize this issue and get the word out.
Thank you, Dave.
You
Any more comments from the board?
Just a question. I know we spend a lot of time educating our consumers on how to protect themselves from bad actors. Just referencing back to the aiding and abetting unlicensed contractor and contractors that are using someone else's license that is in good standing, how are we educating, or what is there data of how many contractors are using licenses that belong to them that are actually out there doing work and tricking our consumers into thinking that they're legitimate and they're not, and then they get burned? How are we educating that part of that issue for the consumer?
Steve, may you take the lead on that? You want to?
I'm not aware of any data that tracks that. Usually, the way we find out about that is a consumer contracts with an unlicensed contractor, and then the job goes bad, and they file a complaint with us, and then that's when we realize that they were using a license number that belongs to somebody else.
Yeah, I would just add that the penalties for contracting with somebody else's license number are quite severe. I don't know if it gets charged as a felony, but it certainly gets charged as a misdemeanor. I don't know that we see a lot of that happening. I mean, one thing we encourage all consumers to do is to check the license. You know, our slogan is check the license first, to go to the CSLB website, check the license, see who it's issued to, the name, style, and also the personnel of record. By the event you're using somebody else's license, you can't do that anymore, that you could use somebody else's driver's license to drive a car. Now, I don't think we see a whole lot of that, but when we do, that would be something that could be filed, you know, could be referred to a district attorney and ask them to consider filing criminal charges for.
Thank you.
Thank you. All right. Any more comments from the board?
I have a comment. I don't know what our position is on partnering with escrow companies. There's quite a few escrow companies out there. But as many of you know, when you go through a bank, you have tons of documents to sign. Most people don't read them in detail. They just sign it to get what they need. But when you're going through escrow, you pay more attention. And perhaps there could be a document that is provided through the escrow companies to the consumers where they actually sign off on that they have read it, so that they have something to look at that might be helpful in alerting them about the Contractor State License Board as well. Thank you.
Thank you, Diana. Any more comments from the board? Seeing none. Are there any comments from the public?
Hi, my name's Amy Pierce. I'm an attorney. I have a couple of points of clarification on this. Talking specifically about solar contractors, when they take on a solar project, they have to order panels and equipment, and it's all typically special ordered when you're dealing with smaller solar contractors. A lot of them cannot take the risk that they're going to order thousands of dollars worth of specialized equipment and then have the homeowner not pay for it. Even if they order the equipment and have it ready for a project, often that equipment needs to be protected from the weather and other sorts of things, so it doesn't make sense to store it at the homeowner's residence. I would appreciate some guidance from the licensing board when we're dealing with special order items, expensive items, right? How we come to a fair resolution of this issue rather than saying you, contractor, don't get paid until a point that really is not feasible. I have a second question for you. This came up at a recent meeting with Mr. Grove about final payment on a solar project. There were comments made that final payment is not to be collected when the contractor is done with their work, but only after the system has been energized and is fully operational from a regulatory standpoint. This is often outside the hands of the contractor. They will energize the system, test the system, and then the system, literally the power, the power switch for it is, or the breaker box is turned off for it. That is another issue that I think there is confusion about. When a contractor finishes their work, they do expect to get paid that final payment rather than holding off and waiting until there is some other point in time, some action takes place that is beyond their control.
I'm sympathetic to the concern that the special order material, but working here, we see way too many consumers being financially harmed by contractors that are being paid for work or material that's not supplied. I would just suggest that a contractor may want to consider getting a payment of performance bond. Many of the larger contractors have that. They can then receive 100% of the contract up front. Now, also, contractors have the ability to file a mechanics lien when they're not paid. In some industries, it's not that uncommon for consumers to pay directly for the materials. You could do that separate. Be happy to discuss this with you further. But that's a real concern, though, when money's being paid for something that the consumer's not in possession of, and then out literally tens of thousands of dollars. As it relates to the final payment, there's an operation for use issue with solar. I mean, is the solar system actually functioning? We're getting 200 to 300 consumer complaints a month for solar here, and it's just not sustainable. And it could be avoided if contractors would have a final payment. I'm not suggesting you have to keep half the contract price as your final payment, but the final payment should not be made, and it could be something that's equivalent to what it would take to get it hooked up through PG&E and get the permit signed off until that system actually works, because we get a tremendous number of complaints here where consumer says, I've paid my contract in full and I'm not benefiting from it. The system's not functioning. I'm still paying the public utility. And that's a problem for us. So we're looking to work with the industry and finding a solution, but the solution has to be solar customers or consumers that are happy with the contracting process and don't feel the need to file a complaint with the Contractor State License Board.
I just want to clarify that it's my understanding that the system is fully installed, the system is fully operational, it is turned on and tested, and it was capable of operating, but it is the third-party regulator that is holding this up. So to me, it is unfair to hold the contractor responsible for not getting that final payment until the system is actually up and operational.
And I appreciate your comment. I appreciate your comment. I appreciate you just reaching out to staff and so we can continue this dialogue. Thank you.
Thank you, Chair Mark. Thank you, Amy, for your comments, and Dave for your explanation on that. Any other public comment? Seeing none. The final agenda item is E3, which is an update on the Consumer Satisfaction Survey. I will turn it back over to Chief Grove to provide the update. Steve.
Thank you, Member Cobos. This update begins on page 135 of your packet, includes the full report for the 2023-2024 fiscal year. Unfortunately, you'll see that there has been a slight decline in the overall survey results from last fiscal year. Enforcement Management is very concerned about this decline and are currently looking at ways to improve future survey results. For background into likely causes of the reduction in consumer satisfaction, I will now provide some of the contributing factors and action taken by management. As previously mentioned, there has been a troubling increase in consumer-filed solar complaints. As of September 1st, 2024, the Enforcement Division had 830 open solar complaints, which is about 13% of the total CSLB open complaints. This excessive number of solar complaints has created high caseloads for enforcement staff, which results in delays in mediation and investigation of those complaints. The egregiousness of solar complaints further contributes to a workload issue, as these cases often include elder abuse, fraud, diversion of construction funds, and have to be prioritized over other complaints. To provide effective consumer protection and address this unsustainable increase in consumer-filed solar complaints, the previously mentioned multiple offender unit was established in December of 2023. Just recently, in July, 2 former CSLB investigators have been hired as retired annuitants and are currently assisting in the multiple offender unit. Another trend we are seeing that likely contributes to a decrease in consumer satisfaction is an increase in the number of complaints in which the contractor has violated the law by requesting and receiving payments in excess of the value of work performed or materials delivered. While these types of cases often result in administrative or criminal legal action against the violator, often the consumer does not receive any financial restitution when the license is revoked and/or the contractor files for bankruptcy. In an effort to increase consumer protection, on September 5th, 2024, a memorandum was sent to all enforcement staff reminding the importance of enforcing down payment and progress payment limitations. And as previously mentioned by Registrar Fote, it is a misdemeanor to request or receive payments in excess of the value of work performed. And finally, as previously discussed by Registrar Fote, in alignment with one of the Executive Division's 2025-2027 strategic objectives, the Enforcement Division is exploring the possibility of creating a new training and development unit to improve new employee onboarding and provide continued formal structured training for all CSLB employees, which would include customer service. This includes the update on the consumer satisfaction survey. Unless anyone has any questions, I turn it back over to Member Kobos.
Thank you, Steve. Do any of the members of the board have any comments?
I have a question. On page 139, the questionnaire statements. Question number 1 seems to be substantially lower from 2019 to current. Can you tell me what is our time element for the consumer to be contacted back? How long does it generally take us?
Thank you for that question, Member Love. This survey question has always kind of baffled me. For one thing, promptly is kind of subjective. So I've talked to Registrar Fote about this, and I'm hoping that maybe in the future we can make some changes to some of these questions and get some more accurate data that's easier for us to digest and then make improvements on. But to answer your question, when a complaint is received in our intake mediation center, within about 2 to 3 days, a letter is automatically generated that's sent to the complainant, notifying them of receipt of the complaint and the contact information for CSLB staff. And then shortly after, well, again, here's where high caseloads come into play. The next step is for the staff services analyst to contact the consumer, but with high caseloads, that can be delayed.
And then I have one more question. On page 140, the graph that is there, if we in fact ever do another survey, is it possible to ask the consumer, out of this is saying how many people inquired about the contractor's license status before they hired them. I would like to know how many people actually knew to do it and neglected to do it.
It's a great suggestion.
Can I make a comment on that, if we would? Actually, I'd like to ask Carol to maybe take that into consideration. The survey is done by licensing staff, and so you could maybe consider adding that question.
Yes, we'd be happy to. And Steve, Dave, board members, if you would like to meet and change some of these questions, we're happy to do it. Carl in the testing division has worked on this survey for many years and is open to us changing these questions if we need to get information that's better for you.
Thank you, Carol. Any other comments from the board?
Yeah, I had a comment. I've been in the industry, construction industry, for 34 years, and one common conversation that we've had is that the construction industry is broken. And part of that is customer complaints, high prices, lack of satisfaction, you name it. There's many things. And we're inundated with trying to improve the industry, but it seems overwhelming because there's always something that gets in the way from making real progress. And when I look at the survey, and it's easy to say, oh, you got a bad report card. But when we think about why this is happening in regards to, just say solar, for instance, with the overwhelming amount of complaints and requires your people to go out and solve these problems that are hundreds to the amount of people you have staff to actually solve the problem, it's broken. And so it's are we looking at it from that kind of holistic point of view of every year we could look at this for the next 5 years and we're going to continue to have more complaints. We're going to continue to have solar companies that come out and are fraudulent and harm our consumers. And I would like for us to think about different strategies of how we address this issue and we continue to see these numbers decline, and easy to point a finger and say, well, the staff's not doing their job, and that's a morale, issue as well. So it reminds me of the comment of the system, the industry is broken, and are we looking at the right things to really achieve what we're trying to find, or achieve the goals that we're trying to get is satisfying the customer, addressing the issues. But if we're doing it with an staff group, how do we really achieve that goal?
Chair Mark?
Thank you. I appreciate that comment, and because of within our enforcement strategic update, I'll make sure I highlight that number 2.4, leveraging partnerships with external stakeholders groups to increase support for enforcement efforts and improve compliance. There is so many outside groups, including contractor associations, that yes, construction, we need to do better. We need to have better customer service as a board, but how does this board do that? And we have a strategy in place. Enforcement Chair Kobos did state that within there. And I think over the next year, we as a board continue to think how we can support some of those enforcement strategies to increase the overall industry.
Yeah, I just wanted to add something that we have approximately, the Contractors Board has approximately 245,000 licensed contractors, and the majority of them do a phenomenal job. If they all received a complaint each year, you'd have 245,000 complaints. When we were going through the sunset review process, we tracked how many complaints we were receiving 5 years ago, how many we're receiving today. If you take solar out of the equation, we've received 1% more complaints for all other trades combined today than we did 5 years ago. The problem really is solar increased by about, I think it was 178%. We're staffed to handle 1,100 consumer complaints a month. That's what we're staffed for. And we're getting 1,300. And so that's 200 too many. And you really see that, and I think when you look at the customer satisfaction survey, they want timely service, and we want to be able to take out the bad contractors quickly. The problem, though, is we're receiving too many complaints. We want consumers to hire a licensed contractor and have a satisfactory experience. So why are we getting too many complaints? Well, quite frankly, we have some contractors that are getting a lot of complaints, and that's why we've established the multiple offender unit. Contractors that think it's okay to use the Contractors Board as a quality control are finding out that it's not okay. You're going to get an accusation to get your license revoked. Thing is here, if we have contractors that are licensed that are getting a number of complaints, they're not going to be able to continue to do business, and that's going to solve a lot of this problem. If we had our complaint load down, it wouldn't be a problem to be contacting people quickly when a case is referred to an investigative center. But when you have an investigator that's carrying 50 or 60 complaints, the process slows down, and we know our consumers, who we rely on to help us regulate the industry, are not as satisfied with that. So that's really the goal, and we're hopeful that the multiple offender unit is going to be successful, and we're constantly getting input from staff on how we can better serve the public.
Thank you, Dave. Yeah, it's just a comment from myself. It seems like whether it's a preventive measures or additional training that maybe these contractors need to have, you know, I know they take the test and take the business part and the trade part, maybe ethics part. I don't know how much of the test is comprised of ethics, but just something is needed as far as educating them in advance before they start contracting. So anyways, any comments from the public? Seeing none. Thank you. This concludes the enforcement items on the agenda. Back to Chair Mark.
Thank you. And what we're going to do, we're going to take a 10-minute break. We'll stop at, come back at 11:05. And just to give staff a heads up, we are going to move items around in our agenda. We're going to move Chair Love will be next for Public Affairs, then Licensing Chair. We're going to change our order in our agenda going forward. So I'll see you back at 11:05.